Hello, thank you so much for joining us. I'm Luis Maria Palma, President of the International Association for Court Administration, IACA. At the start of this new and exciting IACA webinar, I want to express my gratitude to the experts who made it possible. As many of you know, IACA is an international nonprofit organization founded in 2004 with the purpose of promoting and enhancing professional court administration and management in emerging democracies and other nations dedicated to upholding the rule of law. I want to share with you that we will be celebrating the 20th anniversary of IACA during our international conference, which will be held in Singapore from November the 11th to the 14th, 2024. The IACA conference is a significant event for judges and senior court administrators worldwide to exchange insights and perspectives on current developments and best practices in court administration. The theme of the Singapore conference is building trust in the judiciary with a focus on 5 areas: navigating artificial intelligence in the justice system, disinformation and its impact on trust in the judiciary, access to justice and its impact on trust in the judiciary, access to justice central to court leadership and the professionalism of court administrators, and excellent courts in the administration of justice. Precisely, and in relation to the theme of this webinar, our first conference plenary will be devoted to the topic artificial intelligence, governance, and the justice system. And some of the experts who honor us today will be participating as speakers. The conference agenda is available on the IACA website at www.iaca.ws, and experts from over 20 countries of 5 continents will participate as speakers. Conference registration can be accessed through the website, where you can also find information about Singapore and the hotels that will be offering discounted rates. The registration fee, for which we have an early bird one until September the 15th, includes the cost of all conference events and activities, refreshments, breaks, and lunches. We are looking forward to seeing you then. I'll leave you now with my dear friend, President-elect Pam Harris. Thank you and enjoy.
Thank you, Luis, and thank you to our esteemed panel for agreeing to present this topic today. As Luis indicated, my name is Pam Harris, and I'm the President-elect of IACA, and it's a pleasure to be here with all of you today. As many of you know, IACA's mission is to promote professional court administration and management in emerging democracies and in other countries pursuing the rule of law. To effectively do that, we endeavor to serve as an implementer in providing subject matter experts for judges, court administrators, managers, and others associated with the functioning of courts, in searching for ways for courts to anticipate and effect change, evaluate, and improve their system of justice. To carry that out efficiently, we sponsor international conferences, forums, and educational programs relative to the administration of justice, such as this webinar today, addressing a highly important topic with which all of us are faced. AI is transforming industries, driving new technologies and discoveries, and importantly, shaping our lives in ways we could only imagine a very short time ago. We hope that you leave here today inspired with new knowledge from our leading experts. And at the Singapore conference in November, we hope that you will join with us at that event, where we will dive deeper into the subject matter by embracing the spirit of curiosity and innovation that defines our conference agenda. Thank you for joining us today in this engaging session, and we look forward to seeing you in Singapore. Without further ado, I will give this to Norman.
Thank you, Pam. Thank you, Luis Maria. Yes, we've got a great webinar today, and the title is Artificial Intelligence in the Courts, Opportunities and Challenges. And before we get into the meat of the matter, I've got a couple of just sort of housekeeping things to relate. Translated captions are available by using the Show Captions button in your Zoom controls toolbar. A link to the guide for using the translated captions is being placed in the chat. I just saw it appear. All attendees will be muted for today's webinar. We welcome any questions for the panelists, but please submit them in the Q&A button on the control panel. You may send in your questions at any time during the presentation. We will collect these and address as many as we can at the end of today's presentation, where we do have a Q&A time period. Time is going to be kind of short, so we probably won't be able to get to do ever, because I think we have got over 200 people attending the webinar today. So send your questions in, but I'm sorry if we don't get to yours. This webinar is recorded. The recording will be available on IACA's YouTube page, along with recordings from prior webinars and conferences. And there's also a link to the YouTube page appearing in the chat. Speaker biographies are available on the conference website, IACA website. I think Stacy's going to put a link to that as well. And because of that, I'm not going to spend a whole lot of time introducing today's speakers because we need to get to the meat of the matter, as I said. But just to quickly in turn, we've got Dory Reiling, who's a retired senior judge and justice and digital transformation expert, has been speaking on IT subjects for many, many years, is a real wonderful speaker that I've met in person, and I'm really pleased to have her on the panel today. We also have Kevin Bowling, the Chief Administrative Officer of IACA, but that doesn't tell the whole tale. Kevin is a retired court administrator and magistrate from Michigan in the United States, and a past president of the National Association for Court Management. We have Karine Cowan, Executive Director for the Center for AI and Digital Policy Europe. And in particular, what impressed me is that I just learned is that she helped draft the Council of Europe's Treaty on AI. And so when she's going to talk about governance issues, which is right down a very important part of what we're going to talk about today. So I'm excited to hear from Karine on that. We have Giuseppe Fazzari, known as to his friends as Joe. And he's a faculty member at the University of Monmouth and teaches there, has written a wonderful textbook recently, a year or so ago, it was published on court administration, and a former trial court administrator in the New Jersey, United States court system, and is a prolific writer. And then last we have, but not least, of course, is Ten Ken Hui, Chief Transformation and Innovation Officer for the Supreme Court of Singapore. Has a legal and IT background, and so I'm really going to be excited to hear about what he has to say about the IT specifics and also what's going on in Singapore, which is a nice preview again of what's going to happen at the conference coming up. We have a broad range of topics today. We can't cover everything. When we first started organizing this, I had a long list of things that we could talk about, and we've narrowed it down to take advantage of the expertise of each of our speakers. So I apologize in advance if we don't cover something you do specifically want to hear about, but Kevin's going to talk about resources later on, and you can dive in there. So we're highlighting key areas. Why don't we get started? And Dory is our first up on our panel. And so take it away, Dory. Let's talk about AI and where we're at and what's going on.
Okay, thank you, Norman, for that wonderful introduction. As you can see, I'm in a sort of unusual place for a webinar. When the request came to participate in this webinar, I had a really difficult choice to make because I knew it would be in the middle of my holiday. And of course, my first urge was to say no. But Kevin kept insisting, and with all kinds of nice arguments, ultimately I thought, oh, well, why the hell not? And so here I am in a campsite on my iPad. Unfortunately, on the iPad, I cannot operate my own presentation. So I think Stacy has the presentation, and she's going to start it. There we are. And I hope I still remember what I thought when I made it. But I guess I will. I've been thinking and writing about artificial intelligence in courts for, I think now about 8 years. And my article in the IACA journal is at the bottom, if you would like to have a look at that. But it needs an update because it was published in 2020 and things move very quickly. Anyway, this is the title of my what the organizers would like me to talk about: challenges, issues, and what is the status of AI in courts. So please, the next slide. Okay, so behind this title, obviously, you cannot see what's behind it, but let me tell you, it is the world's first automobile that was developed in the 1890s. And what happened, people started driving this car and maybe other cars. There were almost no cars on the road, but people got killed because there were no traffic rules, no security, no regulations. And so the problem then was how to deal with road traffic. By now, we know that for road traffic, we have all sorts of very complicated rules, and you have to have a driving license and all sorts of things. So if we go to the next slide, there is a rather sobering picture there. It is a picture of a self-driving car that drove itself into something that it shouldn't have, which goes to show that this car isn't very intelligent yet, and people still get killed. And the question with AI now is how to deal with those. So in my next slide, let's have a look at something you have probably all done, and that is experiment with AI. So this is my little experiment with Copilot. I asked Copilot to give me a picture of a Dutch court, and no idea what it came up with, but what it came up with was the picture on the left. Now you can see that there are tulips everywhere, and the building looks a little like the Rijksmuseum, and people come to court by boat. So it's a very romantic picture. And of course, it's not what life is like at all, because on the right-hand side, you see my court in Amsterdam. This is what a real court looks like. And I think I would like the next slide. Can you just click? Yes. So the problem with talking about the status of AI in courts in Europe is that it's very hard to find good, solid sources for it. And one of the sources that this slide is about is the survey that was done by the Consultative Council of European Judges for their opinion 26, that is it's about moving forward with technology. And what they do is before they write the report, they do a survey asking what's going on in your court technology-wise. And so the 33 members all replied to the survey, and 9 of them mentioned something that had to do with AI. Question was, what AI do you use in your courts? And on the right-hand side, you see what the answers were. Our government has a government strategy, one of them said. The other one, someone else said, we have a vision. The third said, we have a plan for measures. The fourth one, I find that one very interesting, is we're setting up a think tank. That is in Germany. It's in the Supreme Court of Cologne, and you can look it up if you want. We have some initiatives. We're doing pilot projects. We have ideas, and we're experimenting with chatbots. So this is a lot of stuff, but it also means that there is no, let's say, implemented AI technology in the courts as such. Next slide, please. Please. So that I found was a discussion between court managers in the US. They have a knowledge base on the use of AI, and very interesting what was happening there. I know from Paul Embley that they are also experimenting with chat boxes. Interesting to see what's going on there. Sentencing algorithms, we'll talk a little bit more about that later, give robust guidance, they say. Okay, so translations, not in the courtroom, but just for customer service. So no translations in the courtroom yet, as I understand this. This was a fairly recent Zoom talk that they did. Data extraction, courts control their data and do not give outsiders access to it. Of course, it's a little hard to understand what exactly that entails from this, but this is what we have. Speech to text still at a low level because speech to text has difficulty recognizing all those accents. For instance, in the LA courts, they have, I think, about 180 languages. That would be really hard. So this is what's going on in the US, and that's also, most of it is back office, or it's something that the judges still control themselves. Next slide, please. So, but of course, the most interesting things are happening in Asia. So again, Copilot, I asked Copilot what's happening in AI in courts in Asia. And what I got, and I used that here deliberately, was sources from mostly from the press, from newspapers. But I thought it would be interesting to have a look at that. Anyway, China has a government AI strategy. They're recording testimony. They're doing all sorts of things. And the idea in the People's Republic of China is that the systems for the courts will actually put a fairly heavy control on the work that the judges do. And there's more about that. There's an article at the bottom there if you'd like to know more about it. Then in the next slide, a little bit about Singapore. I have visited Singapore several times and see what they do. And what this article said that Singapore is trying to help self-representing litigants with generative AI. Now that would also be interesting to see, and I'm sure you will hear more about that at the conference. India, next slide. India's Chief Justice had a talk reported by the Times of India and told the audience that they are having an initiative with live transcription. That's another thing that looks like a fairly obvious application to be used. I know there's a lot more going on in India, but this is what I found when I asked Copilot what's happening. So, and now Malaysia, please. The next one. Malaysia apparently still uses AI incidentally and for predicting sentences. And South Korea, I know South Korea is pretty much advanced. I visited South Korea, I think in 2017, and had a look at their lab and everything. They're very active integrating AI tools in their processes to enhance the processes themselves. And there's a reference to an article there as well. So next slide, please. Oh, no, just hang on. Can I have this one, please? All the examples that Copilot could find were applications for lawyers. I could not find any applications for judges. I'm sure they are there, but I couldn't find them. Okay, next slide, please. So I also needed to talk about issues. Now, there are issues with practically everything. AI, there are data issues. The problem with data is that the data collections that we have were not collected to be used by AI. They were used to do case management and things like that. There can be problems in the algorithms for all sorts of reasons. For instance, because of the way that the person who designed the algorithm thinks that processes should run. That may not always be like my example with the court, the building of the court buildings picture. That is, so algorithms do not always do what you need them to. Problems with consistency. If the algorithm has done some learning, it may come up with a different result. And then there is accountability. That's an issue that is being debated quite a lot, because if you come up with a result, how can you explain how you came up with that result? Now, I know that the AI developers are working with that. There's ChatGPT now is already a lot more accountable than it was, but still it's something that especially in the judiciary we should keep in mind. So those are issues with the AI, but judiciaries are confronted with another set of major issues coming from the AI. One of them is discretion. If we rely on AI to take our decisions, where is the room that we need to react to unusual arguments, new situations, things that change developments? There is confidentiality. A colleague of mine recently used ChatGPT to ask a question, and you have to input some data for the question to be answered. Now, where do those data go? We know that right now the data are being used to train the AI. So you have no control over where your data go. So judiciaries need to deal with this in a way that does conform to the confidentiality that is expected of us. And my basic issue for judiciary is how can we make sure that the users, the judges, the people in the court, parties, can be in control of the AI that they use and be accountable. And one of the things they need to do is to be aware of the risks that AI entails, that they need to be accountable, and of course also how these responsibilities are reflected in our governance. And I think I decided to leave the governance to Corinne because she knows a lot more about that than I do. I think, can I have the next slide, please? Yeah, just this one, the European Ethical Charter. It was my privilege to help CEPEJ put this together. And the really, to my extent, to my mind, most important rule here is to keep the AI under human control. And sometimes people tell me and say, oh, but we can't. And well, no good, we have to. This is the only way forward. Can I have the next slide, please? So what judiciaries by now have been thinking a little bit about, or a lot about, using AI in courts. And for instance, in the UK, they've come up with a number of rules. And one of them is to use AI not to make decisions, but just for supportive purposes. Understand how it works, be aware of the bias, and keep the confidentiality. Well, you know what I mean when I say confidentiality. Our let's say the duties that we have with our data. And the question that now arises, a couple of years ago, predictive justice was all the rage. But now somehow the discussion has moved, and I wonder where, because does that mean predictive justice is dead? Has it disappeared? Where did it go? I don't know. I'd like to know more. Next slide, please. Another list of challenges for courts, and I think this is my last slide. And anyway, it's the conclusion of my article. There needs to be human control over this, and judiciary control over the design of the AI, about its development, and of safeguarding its correct workings. If you use AI for, let's say, to support decision making, you have to make sure that it stays working the way you want it to, and that is probably going to have to be daily business for the courts. The other thing is that it might be a good idea to improve the input in our data systems. Make sure the data are correct. I don't know about your data, but I do know a little bit about the data in the courts in the Netherlands. They were not collected for these purposes, and I'm sure that they are not all of them. I know they're not all of them correct because I've checked some of them. Data need to be kept secure. There need to be enough data. That's another one. You cannot, let's say, have AI predict on, let's say, 10 court decisions. And court decisions, judgments, could be made more machine processable, so they would be easier to process for AI. And I think that this to-do list, do I have another to-do list, or is this the last one? Can you give me the next slide, please? Yeah, that's the last one. Okay, thank you very much. I hope I've told you something you didn't know yet. Any questions? I will be happy to answer them.
Okay, that was a pretty nice comprehensive introduction with listing at a host of issues, which we could spend all day talking about the various things that you've raised, Dory. So my mind is going, whoa, here. So thank you very much for that. In the interest of time, however, and other panelists, I think we need to move on, and we'll address any questions people have specifically for you, hopefully in the Q&A later on. I do love your references to the International Journal for Court Administration, the two articles, yours and the most recent one, which have wonderful materials there. So I know Kevin is going to talk about references and such, but so take it away, Kevin, and talk about, why AI and some use cases and the resources.
Thank you, Norman, and thank you, Judge Reeling, for the great intro comments there. I think they were really helpful. And I was glad to see that you used Copilot as one of those models as you set this up. I was curious how to start things off today. And as I often do, rather than trying to come up with something entirely on my own, I asked Copilot how to start a conversation like that. So here's what Copilot suggested to everyone. Imagine a courtroom where backlogs are a relic of the past, where justice is swift, and where human biases are minimized. This is not a distant utopia, but a potential reality within our grasp, thanks to the transformative power of artificial intelligence. I think for many of us, as we think about artificial intelligence, it has scared some of us. Certainly a number of the judges and court administrators I've spoken with have been frightened by the potential harm that it can cause in the court realm. And I think part of our message to everyone today is to embrace it, to not be scared of it, but to understand, I think, as the judge talked about, and I think as we'll hear from others about the need for good governance, there need to be guardrails that are put into place. And we have some responsibility for doing that. And our hope is that some of what we touch on today is going to help us go down that road. But also to start off, as Luis mentioned in his opening comments, AI is going to be a major topic at the Singapore conference. And I would like to ask all of the participants on the webinar today to help us out by answering a few questions while you're listening to the webinar. And you can just put your responses in the chat or in the Q&A. But we're curious about how many of you are allowed to use AI in your courts today. Who's actually using it? And if you're allowed to, have you taken that step to implement some AI? And if so, what is it? Just so that we can get an idea from various courts in different countries, who's using it, how effective is it for you? And especially, do you have any guidelines in your court? Because if any of your jurisdictions have taken the time to implement AI and have developed some guidelines, what you've done might be very helpful to other IACA members and other court managers and judges around the world. So we would like to share that. And if you have any thoughts about practical uses, even if you haven't implemented it, but something that you think would be very helpful in your jurisdiction, we'd love to hear from you. So feel free to add some information in the chat. The next slide, Stacy, please, if we can put up some of the slides that are, here we go. We could go to the second one. One of the key things that also throws some of us in the court world off is just figuring out what is artificial intelligence. There we go. The reality is, and I think all of the panelists have probably talked about or written about different versions of it, but there isn't a consensus definition, at least not one that I've found yet. Everyone has a little different idea of what it involves, even going back to the original Turing test of, what kind of intelligent behavior can a machine share. In the next slide, there is a whole range of artificial intelligent applications that come under this umbrella that we call AI. And Stacy, you might need to click once or twice through here to add, there we go. So there's a lot of things when we're talking about AI where we could be looking at machine learning. It could be natural language processing. It could be different kinds of expert systems. We're going to get to the point where we talk about speech and artwork and robotics, a whole variety of things. And often when we're talking about artificial intelligence applications in courts, we seem to focus more specifically on generative AI with some of the examples that we use. So I just want to make sure everybody's on the same page and understanding that artificial intelligence means a lot of different things to a lot of different people. If we go to the next slide, please. One of those generative AI areas is ChatGPT. And I just wanted to briefly mention some comments that came from the founder of the company that created ChatGPT, where when they first kicked it off or in 2022, Sam Altman mentioned that it has no source of truth. And that sometimes it writes plausible sounding but incorrect or nonsensical answers. And in the court world, where we rely on the written word for much of what we do and for the precedent that many of our court decisions are based on, that's a concern. And Sam also said in 2022, it's a mistake to be relying on this for anything important right now. It's a preview of progress. It's what we have to come. But in a very short time, just in 1 year, by the time we got to last year, look at the next slide and some of the things that this same ChatGPT that Sam warned us about started doing. So if we can go to the next slide, Stacy. When we got to ChatGPT 4, now we've got AI that can effectively read, can summarize, can annotate, can analyze, translate, categorize, synthesize, interpret, and do many more things. Most of the generative AI models that we think of in terms of text and how it's dealing with text. But as we'll hear from others, there's different types of generative AI that can do coding for our technologists, that can create artwork that would be hard to contrast with masters. I thought it would be at one point fun with Dory on, with her background in the Netherlands, to have some of the Dutch masters paintings and see what AI would do with a current version of them. But if we go to the next slide, please. One of the questions that keeps coming up is when we look at the capabilities that AI has, why is it different from other tech advancements? We've all lived through tech advancements in our careers. We saw when fax machines were phased out in many courts, and we had different computer technology that came in. I have some employees today that don't know what a typewriter is and wouldn't know how to use it if it showed up on their desk. So we've seen transitions with different technology. We've seen it with cell phones. We've seen it with email, with electronic filing in courts. But the question that keeps coming up is, why is AI so different? And I have a couple of thoughts about that. On the next slide, I think one of the reasons is just the variety of people and companies that are involved around the world in the development of AI and the resources that have been put into it. I found a Stanford University analysis that indicated with the number of companies that are involved around the world from 2013 to 2022, in that 10-year period, $934.2 billion was invested in the development of AI. Today, that same analysis, Stacy, if you just click once, indicates that by 2027, we're going to see an annual investment in AI of at least $50 billion. That's one of the reasons AI is different, just because of the investment that's put into it. And on the next slide, we start to see a couple of examples of things that just throw us off a little bit about AI and how it can impact the courts. And hallucinations are one of those big areas where we see that. The interesting thing is some new developments that are coming out now, for instance, as we move from ChatGPT 4 to ChatGPT 5, some of the folks that are working on it are suggesting now that hallucinations are going to disappear. It's something that we're worried about now. I'm seeing some of the other panelists shaking their heads and probably scratching their heads. So it'll be interesting to see what the developers argue about this and what we actually experience. The next slide shows an area that is of concern to many judges around the world, and that's with deep fakes. We've all seen examples of this. And we know that digital evidence as it comes into the court can be very misleading. There are tools that are being developed to detect it and make it easier for judges and judicial officers to responsibly evaluate evidence that's coming in. And there's a big question about whether attorneys or litigants are accountable. Is the responsibility on them to make sure that any AI being used is appropriate and is correct, or is it on the court to catch whatever is going on there? So, and the last example that I had on the next slide has to do with, Dory touched on this a little bit, but AI-generated judicial decisions. Is this appropriate? Are we going to move in that direction where we at some point have the unheard of robot judges that are going to start making sentencing decisions or probationary decisions or monetary decisions in civil cases? There's a lot of concerns about how far do we go, and yet we want to be able to use AI where it is most helpful, and perhaps there are ways that we can do that. And that gets to, Norman mentioned some resources that I was going to touch on briefly. On the next couple of slides, there's a reference to a document that was just published last month, actually 2 months ago, July, from the National Association for Court Management here in the US, titled Courting AI, Understanding Artificial Intelligence in Courts. And this guide is intended just to provide some very basic questions for court managers and to give you some ideas of what to think about when you're trying to deal with AI implementations in your court. The next slide, in fact, we may be able to skip to the next one. The Joint Technology Committee, which is based here in the US also, representing the Conference of State Court Administrators, the National Center for State Courts, and the National Association for Court Management, has a number of resource bulletins that are available to court managers and to judges if you're looking for basic information on what AI is, how we might be able to use it, what are some possible use cases, and I can include some links to these documents too in the chat when we get there in a moment. A couple of other resources on the next slide are from the National Center for State Courts. I'll include a link to their AI policy resources, but they have developed an active resource center. They have a group of technologists that meet on a regular basis to update them on what's happening, at least throughout state courts and federal courts here in the United States. So there's a variety of activities. And there's also a rapid response team that has been set up to develop answers to frequently asked questions. So if you go to the next slide, just as an example, there are documents like this that was just published in August of this year, guidance for the use of generative AI in courts. And you can see from the table of contents a variety of areas that are covered in terms of what we should know, evidentiary issues, ethics, developing internal policies, and a variety of other things. And for those of you that may not be avid readers and don't want to go through lengthy documents, there are even some quick references, like on the next slide, where there's just a one-page outline of things that you can do in your court to prepare yourself for success with implementing AI in terms of things like putting a team together, not trying to do it on your own, getting educated, defining what your goals are, and you can read through the rest of them. And then the last couple of things that I wanted to mention when I have to do with actual use cases. And I know that Professor Vazari and Ken and Corinne are probably going to talk about other use cases as well. I just picked a couple because I had an example from a judge that I recently did some work with from the state of Louisiana, but where we talked about very positive use cases in terms of developing informational videos, and some of the dangers I've already touched on. But I have an example in the next slide. If this is an example of generative AI, this is Judge Scott Schlegel, or an image of him. But Stacy, if you hover over his picture, there should be an ability to start him up, and maybe we have to add some volume to it. Well, perhaps it's not going to work here, but the point that I was trying to make with this video here is that any one of us using very inexpensive software can develop materials, training materials in your court to help train staff on a variety of different issues, or to help self-represented litigants better understand court processes, where you can feed a script to AI. It will produce a video like this, and you can also do it in multiple languages. Judge Schlegel has a very strong Southern accent from the US, living in Louisiana. But as we go through this particular example, you might be able to play it if it's available to you after the presentation today. He switches into perfect Spanish and then into fluent French as he's going through and explaining some of these court procedures. So it's just some examples of things that you could do if you chose to and wanted to look at some inexpensive software that's available to you.
Okay. Kevin?
Yes.
I am going to jump in because
All right.
we have other panelists that we need to move on to.
No problem.
It's great, but
Thank you.
We have got some time limits here, and we can loop back to some of the things that maybe you didn't cover when we get in Q&A. But I'd like to move on and bring on Ken from Singapore, who will talk about some more use case things, risk areas, IT issues. So take it away, Ken. You're muted, Ken.
Yeah.
Ken, you need to unmute, please. Stacy, can you unmute him? There we go.
All right. So sorry about that. Okay, I'm going to breeze through these three very quick slides. And I just wanted to speak to some of the things that have been mentioned so far. We've been chasing the AI craze in Singapore, and we've identified a whole slew of different use cases. I'm just going to talk about a couple of them. I've added a ninth to this slide, but I'm just going to start with summaries of cases. In our experience with the Gen AI tools that we're seeing, is actually reasonably credible for giving us summaries of cases and summaries of evidence as well. So we can quite easily ask the Gen AI tool to give us a quick synopsis of what a case is about. It is not going to be 100% comprehensive, but it would give a judge a fairly good idea of what a particular case is about. Number two on the list there is the ability to talk to the evidence. We had a recent case where there were 850 volumes of the agreed bundle. So that's about 850, about 500 pages per volume. That's 400,000 pages that was submitted to court by parties as being the agreed bundle. There is no way that you can expect any judge or opposing counsel to properly traverse and to understand 425,000 pages of material. The GenAI tools allow you quite reasonably to be able to talk to the evidence, to ask, for example, how often did Alex write to Bill about the proposed licensing agreement between two entities? And even simple things as construct a chronology related to that particular transaction is actually fairly decent at being able to deliver those results. From the perspective of court administrators, the third use case that I've listed here is interesting. The ability to perhaps help us in scheduling cases. So can we have a smarter scheduling of cases to take into account perhaps predictions as to the number of cases that might be settled before trial, or perhaps even specialized lists, right? So for example, can I ask a software tool to find me 5 continuous days before a judge on list 9 in November 2024, even if that means that I have to take another case away from that judge, right? The interesting thing is we studied this a fair bit, and the technologists tell us, well, okay, yes, we can build this for you, but you know what? It's not AI. It's a lot simpler than AI. And that is going to lead into one of my conclusions in my third slide. Number 4 on my list is, can we use AI to help unrepresented litigants prepare for oral hearings? So one of our first use cases for generative AI will be small claims court cases. I will talk more about this in November. And so can we help an unrepresented litigant sift through all his evidence and to prepare a summary or perhaps the most persuasive way that he might be able to present his case in an oral hearing, right? Ultimately, the litigant has to be responsible for checking whether or not this is indeed something he wants to do. And again, this point of being responsible for the output of GenAI is something that I will return to later as well. Number 5 on my list here is, can we use GenAI to help judges prepare draft judgments? Now, this is extremely interesting and may seem to veer into helping a judge decide, but I would draw a sharp distinction there. And I would say it's one thing to say that the judge says he's decided in favor of Alice and not Bob. So can we use GenAI to tell the LLM to review all the case documents, and on the basis of the legal reasoning that the judge has decided on, prepare a draft judgment, right, that would reflect that outcome. That's a very interesting use case that we are exploring, and we make a sharp distinction between telling the judge how to decide and helping the judge draft a decision on the basis that the judge has already decided the case. Number 6 on my list is legal research. Can we get generative AI tools to help provide relevant case law and legislation before the court, perhaps synthesized as well, so that you're not just looking at a disparate list of authorities, but actually synthesized and contextualized to the factual matrix of a particular case. Number 7 on this list is access to justice. Access to justice, can we use generative AI tools to help litigants better prepare their court paperwork, to be able to present what they want to say in a way which is easier for everybody to understand without embellishing and without, that word again, hallucinating, right? Number 8 on my list is chatbots. Everybody loves the idea of a chatbot. So might we be able to use GenAI tools to provide citizens with information pertaining to legal procedures? Are chatbots able to give accurate answers? Or should we use something a little bit more traditional, a combination perhaps of chatbots and curated purpose-written content and FAQs? And in the course of this evening's proceedings, I've decided to add number 9 here to address speech-to-text use cases as well as translation. Can we use AI to help with speech-to-text? And that's something that's very dear to the hearts of court administrators. And we all would love to be able to get high-quality live note transcription without paying the price that that service typically costs. But is the technology up to scratch? right? You hear Google and IBM saying that we've reached human equivalence in terms of the quality of speech to text transcription. Is that really the case? Our experience is not quite. It's a fair bit of vaporware and a fair bit of overselling by the vendors. So putting this all together again, very, very quickly, and hopefully I'll have more time to delve into some of this in November. We've devised a sort of a red, amber, and green typology, right? And I think I'm going to start with the bottom. I'm going to start with the material that I think are pretty much in the green zone. And that includes the ability to generate summaries and the ability to help, whether it's lawyers or it's judges, to review evidence. That is pretty much in the green zone for us. When it comes to drafting documents and access to justice use cases, we would say proceed with caution. So that's in the amber zone. And for access to justice use cases in particular, I would like to draw a distinction between the creativity aspects of generative AI tools. It's one thing to ask a generative AI tool to give you a drawing of a dragon flying over Manhattan. You can be fairly imprecise about it. Does the dragon have wings or not? How many wings? You can be fairly imprecise with it and it can still look lovely. But for access to justice use cases where people might make their decisions about whether to lodge a case today or tomorrow in this jurisdiction or that jurisdiction, perhaps precision is more important. And if precision is more important, is a chatbot actually the best way to do this? My answer there, not to give the plot away, is actually no. Squarely in the red zone, for me at least, is the use cases of predicting outcomes and deciding cases, right? I've mentioned a bit about deciding cases. We think that that is pretty much something that we are not exploring anytime in the near future. In terms of even predicting outcomes, we would stress that the generative AI technologies that we are seeing these days, they are language models. They are not knowledge models. They don't recognize hierarchies. If you give it a large volume of cases, even if you code the cases and explain what the cases are all about, it's not going to recognize that the 11th case that you're going to put into that basic number of 10 basic 10 cases, that 11th case actually upset the apple cart for all the other cases. That is a decision of an appeal court that has now made the earlier 10 cases irrelevant. Finally, so what if you can predict that a litigant has an 80% chance of winning a particular case? What do you do with that? What do you do with that information? As a judge, what do you do with that information? As a lawyer advising a client, what do you really do with that information anyway? So we would think that predicting outcomes is really not something that we are particularly keen on exploring. Moving very quickly with just 5 closing points, we would stress from the left to the right that this is not artificial general intelligence. We are not anywhere near the prospect of Skynet taking over and becoming self-aware. As for hallucinations, we are told by quite a lot of technologists that it is a feature, it's not a bug. Don't expect to get rid of it. It will always be there in some form or other. You can try to control it, but it's not going to go away. Right in the middle there is the question of what is the right technology to use. And we have a whole slew of examples where some of the things that we could do in the courts can be done without generative AI and perhaps not even with AI. And then on the right-hand side there, there's a snowflake syndrome. A lot of people think, well, let's generate our own large language model. But when we talk to the technologists and we understand a bit better what the big boys have done in terms of creating a large language model, that's extremely unviable. And anybody that tells you that you can take local case law and train your own LLM, well, they're smoking something. And finally, right on the right-hand side there, I think the ultimate touchstone in terms of how we can use these technologies is that we need to sometimes think that some things can be addressed with a high-tech approach, but there are also a lot of things we do in the courts that have to be done with a high-touch approach. And that's where I am with 1 minute to spare, but I'll return that to you, Norman. Yeah.
Fantastic. Boy, that was a power-packed 10 minutes there, Ken. That was wonderful. And I'm sure we've got lots of thoughts and things to follow up on. And I think people who come down to Singapore for the conference can get an expanded version of this, and we'll really appreciate that. So wonderful. Okay, I think it's time to move on to Joe Fazzari, who's going to talk about something near and dear to my heart, which is workforce and people. And one of my mentors told me a long time ago that people are your most important resource in the courts. And so Joe is going to talk to us about that and how important it really is. So Joe, take it away.
All right. So Norman, thank you for that warm introduction. And thank you to my esteemed colleagues, Luis and Pam and Kevin, for the invitation to join all of you. It's a real pleasure. So if I can get my slides up there. Perfect. Okay, so what I'm going to really very quickly kind of discuss is, and I'd like to call this kind of like the appetizer, right, today to what will be the entree that's served in Singapore in November. So I'm just going to give you kind of the Reader's Digest version here of some of the key points that I'm going to focus in on. And so I've titled, when I was thinking about how I'm going to talk about this human capital piece, I wanted to sort of show the kind of yin and yang, if you will, you know, the positives as well as some of the pitfalls. And so I titled it The Promise and the Peril, right? So we consider both. So it's not all rainbows and unicorns, right? There's some things that we really have to sort of take a look at. So I'm going to go through these 3 points. Next slide. So I'm going to go through these 3 points very, very quickly. So when we think of AI as it applies to HR, frankly, it's really just that. It's data-driven HR. The court is a people business, right? As Norman mentioned, and you know, I think any good mentor is going to tell you, you know, human beings, people are the most important and certainly, frankly, the most expensive commodity any court has. If you look at any budget in a court, when I was managing the court, they made up 93% of my budget. So the O&E expenses, pencils, books, every computer infrastructure really makes a negligible part, relatively speaking. And so the courts are really only as good as, therefore, as the people that organization employs. And so AI, when you're looking at AI, it really needs to be looked at, frankly, as a tool to reach those broader kind of strategic goals rather than something that we want to fear, try to suppress or avoid, because as my colleagues had mentioned, it's not going away. It's here to stay. So what we need to do as court administrators, as court executives, judges, and leaders in you know, this keystone, cornerstone part of any democracy and government is to really look at how do we do this so that we can make it more of a benefit and less of a peril. And so looking at it in terms of data-driven HR, another kind of thing, another sort of analogy I give when I'm looking at AI as it relates to human beings, human resources in the court is really kind of consider it that, as I tell students and judges and administrators, like everything is baseball, right? So everything is data analytics. And so and what that generally means is that decisions moving forward are going to be empirically supported. The decision-making with respect to who you hire, how you hire them, those things, and what AI enables you to do is really create more of an evidence-based approach to those kind of decision-making. And this is not new. If you look outside of the court at the greater market, you'll find that you know, a recent survey by Forbes shows that, you know, more than 2/3 of human resource professionals, when asked, they really see value in AI. They see value in those tools. They see value in that resource. And so there are lots and lots of HR departments across all industries that are already, frankly, using these AI tools in the hiring process. And that hiring process now more than ever is in major transition. And so what is that? So we then have to, that begs the question for us is, what does this transition look like for the courts with respect to taking care and creating an environment for our most able people to come into the courts? How do we get to a place of greater efficiency while at the same time not compromising the integrity of our justice system and how we employ people and what we do with those folks? And so generally speaking, when you're looking at this data-driven HR, there are really 3 major areas in HR that provide sort of the greatest concern. Again, not just in the courts, you're seeing it in the prevalent market. First, it's voice recognition. The second is automation, robot automation, and the third is those algorithms. And I'll touch upon each of those in the next couple of slides. So next slide. Okay, so if you take a look at this next slide, this doesn't relate directly to the court, but it does relate to the wider market, the wider industry. And what you see there is it's a questionnaire. This was done by, and I have the source there if you want to take a look at it. And it shows how the various organizations use AI for it. So what I find most intriguing, you can go through all the different areas and that are impacted. But what's really kind of telling about this is that green bar at the top where it shows that AI tools have no impact on removing job roles. It's not, there are some, for instance, at the top where, there's a good percentage that it doesn't have an impact, but that green bar for any of these categories doesn't go right across the screen. And so therefore, it's showing that it has some level of impact, some more than some more than others. Interestingly enough, the second from the bottom there, what you'll see is legal research, which actually has, one of the higher marks. And so Kevin talked about the $50 billion investment that's going to be done in the long term with respect to AI. When it relates to specifically the technology market as it relates to human resources, there's going to be a $10 billion with a B, a $10 billion growth in the next 5 years, just on human resource technology. And so what that means is, or what we can come to expect as the courts, that they can't be late to the game on with respect to this issue, is that we have to develop ways where we kind of prioritize our own budgets and our own investments and those limited taxpayer coffers to how do we invest in AI in a responsible way to optimize really those business processes and reduce costs in the court, while at the same time, again, not compromising the integrity. And so everything you see with respect to digital disruption, the trend of employees leaving their jobs, are really going to compel the courts, again, not like other organizations, to rely more heavily on this technology and AI, obviously specifically for the tools and resources to fulfill those needs. And next slide. Okay, so what is the promise? Having said all that, what is really the kind of promise? So there's basically, how I see it and everything I've kind of researched about it, preliminarily looking at this, there are really kind of 3 areas. The first is in using AI to recruit. Again, HR departments across the industry already use these tools at various stages in that recruiting process, from reviewing resumes, filtering through them, looking at different applicants, creating applicant tracking systems, and using these AI resource to kind of shortlist candidates. And so for the courts, it could help identify the talent needs that are not presently, that are presently and moving forward. So what does the court portend into the future? What are the critical kind of roles, tasks, responsibilities, qualifications, credentials, skills, experiences? What are those kinds of things that are going to be more critical to the court, not just now, but moving forward into the future? So it helps to identify, or it can help to identify those talent needs. And so, and in that same vein, it helps to create instances where you could take a look at the most qualified candidate pools across the web using these AI-generated kind of advertisements, tailoring it specifically for qualifications or experiences that the court executive and the judge is looking for within those populations. And again, also creating tracking systems that once you bring in these folks, how do you track them compared to what courts are conventionally doing now that involve, in some courts, particularly smaller ones probably, more of those manual processes. The second area, empowering efficient decision-making. So this really kind of deals with filling open positions at a court that could pose difficulty, right? It's a time-consuming experience for human resource personnel, hiring managers, supervisors, staff. It's a time-consuming process. In some instances, particularly in those smaller to mid-sized courts who have fewer persons who are more exclusively assigned to these particular tasks, that can take weeks, months, several months to sort through those applications, set up interviews, and go through that process. So AI here could enable the automation of some of those routine HR tasks, like screening those resumes, answering some of the frequently answered questions that candidates may have, scheduling interviews. And that allows you to then free up more of the time of those HR personnel. It also minimizes, by default, some of that human error that transpires in that process. So it could enhance the fairness, the accuracy of those processes, free up those HR folks to do other types of more important things, while this thing sort of serves as AI serves as essentially as a pseudo assistant or as an aid to that hiring process, resume scoring and the ranking and what have you. And so those non-technical aspects, some of the more, routine technical aspects of going through that process, it could free folks up. Finally, it facilitates what I write as the recognition of patterns and trends. And so, as I mentioned, it could take several months to go through that hiring process. At the same time, it could take several weeks to gather and analyze the same quantity of data that we as human beings do manually or through some rote system that we have operating in the court. The AI process really cuts that, to be negligible. It accomplishes it in really a matter of seconds, minutes, that we can't compute at the same pace. And so that it accelerates the process, therefore, considerably, while enabling, again, the court managers to learn from the things that it's done in the past, creates greater levels of success. It predicts, again, as I mentioned earlier, some of the talent needs within the court, some of the talent needs that could be actually also tailored to specific departments or divisions within the court, the family part, criminal part, probate, civil part. And it also, if you have a generative AI solution, it could also help identify particular candidates who are likely to excel or most likely to excel in specific roles, or in that transition, the employment transition that we're currently in. It could also help the organization, it could help the court flag employees who may be on the verge of seeking new opportunities, right? Who may, some of the best and brightest folks that are in the court who may be on the verge of moving on. It can help flag them that these folks need to be, sort of provided other kind of opportunities to excel and help them thrive in the court. Next slide. Okay, and so what are the pitfalls? So there, as I mentioned before, it isn't all rainbows and unicorns, but if we take a look at this in comprehensive fashion, if we take a look at this with a keen eye, we could avoid some of those ethical issues and challenges that inevitably come up within the system. A very clear issue, obviously, continues to remain a thorny issue, is bias, right? There's inherent bias in the system, and the potential risks that you pose by using AI in this process of hiring, training, professionally developing. There are potential risks of eliminating, frankly, good candidates if you're not planning accordingly, right? If you're not aware of some of these inherent risks. And so ultimately, what you want to take a look at is you want to create goals in the system to utilize these systems to simplify the recruiting process, while at the same time not simplifying it in the sense that you're exacerbating associated risks of bringing in bias in that process. And so, so those are that's a clear top of the line, in your face kind of at the forefront issue. Other issues is the AI system could, and it was mentioned earlier, disseminate incorrect. It could disseminate outdated information about the court's policies or the job role. And that, if you put it out into the public, into the market of people who are potentially looking at our organization as a place of employment, it could lead to this kind of ripple effect of confusion. And at worst, that's at best. At worst, it could potentially create, more serious kind of legal, ethical complications for the court, right? And, it may reflect, some of the issues like, what you're putting in the system is essentially what it's bringing out. And so it could unintentionally reflect some of the historical biases that we as human beings have and bring to the world of the courts, right, and our own personal experiences. So it has to be carefully managed. And so those systems, if not carefully managed, have the potential perpetuating some of those biases. It has the potential of leading to, skewed promotional decisions or hiring decisions. And so it was mentioned earlier too, it bears repeating. It raises privacy questions because of the data that it's collecting on job candidates, on the data, on personal data that it's collecting on the employee and on the employee base, right? It's talking about some of the issues that it brings into the usage of that data, and so courts need to be transparent, frankly, in terms of how they use that data, and they have to use the most robust measures available to protect employee data as well as those candidate would-be potential employees of the courts. And so the line between human beings, when you take a look at these ethical issues and challenges, the line between human beings and this machine interactions can sometimes become blurry with AI. And so you have to bear that in mind. For instance, if a candidate interacts with a generative IA system during that recruitment process, it may question whether their responses are generally understood or valued. So you have to, that bears some serious consideration. You have to bring those issues to bear and make sure that you're transparent in that process. Now, having said all that, there are things that we can do as a court system to ensure that we mitigate, if not altogether, try to eliminate those associated risks. And there are guardrails, right? This is crucial to data teams that they understand, crucial to data that technology uses to understand what is the HR piece in the court. And so in order to use AI to the fullest potential in HR, it's really important that the folks who work on the technology side of the house work very closely, sort of hand in glove with HR. So they have a clear understanding of the HR role, the tasks, associated risks, what they do, avoid kind of the inherent biases and the things that come into play. And so what I like to call it is trying to, in the circuitry, right, of AI, one of the guardrails is to ensure that you have a human being that could short circuit that AI circuitry. Make sure that you have a human being in that decision, in various decision-making roles, so that there's a check and balance in both directions between the machine and the human, right? So you don't, it's not like, the other sort of metaphor I use is it's not like a crock pot, right? Where you put the stuff in, you kind of set it and forget it and walk away. That's not what you want, right? So to create a guardrail is that you're taking the temperature, you're monitoring, you're watching it, right? And you have a human being who has all those ethical considerations in mind in the process. And so a part and parcel of this is what I mentioned earlier in terms of making sure you have this HR liaison work with this IT. So there's always this kind of, so they work in concert, right? There's an integration between what we're doing on the technical aspect to make sure that it's not compromising the human element, right? And to build it in such a way that it's useful to our function, but doesn't compromise it. This requires lots of frequent, obviously, teams, collaboration, everything else. So now best practices is the third piece, is really kind of fostering. It's a part of my model. I talk about court culture is really the most important element when you're talking about a court organization. So fostering a culture that is curious, learns, adapts, and is using AI responsibly. I'm a little short on time, so I'm going to go through this, very, very quickly. So
yeah, Joe,
last,
I'm about to jump in here.
Yeah,
so
last slide. Last slide.
And we need
so
to
best
get
practice is the European. This is brand new. It just came out or just approved, I think, last month. So I'm still becoming familiar myself. But I'm just going to make one point about this: is the fact that I'm intrigued by it, and I think we all should be intrigued by it because it shows that Europe is kind of taking a very interesting lead with this AI Act that was passed last month, and it's really, if you look at it, it's very comprehensive, and they take a very interesting kind of what I like to think about as almost like a horizontal approach that encompasses the full spectrum of AI, as opposed to, or in contrast to what we do here in the United States, which tends to be more specific in nature with the uses. And what you see there is they have unacceptable risk from high risk, limited risk, and minimal risk. So I'm going to implore all the attendees, not that they're really interested in this, that they'll want to get the fuller discussion in Singapore. So I invite all you to join us there. But thank you so much.
Thanks, Joe. All right. It's quarter after the hour, and we've saved Karine Cohn for our final panelist presentation today, because governance is a huge issue, and Joe just teed it up well for us, because the laws, policies, and rules that that courts, governments are in the process of evaluating and promulgating are really key elements in how AI is moving forward. So I'm very happy to now turn it over to Karine to explore that for us.
Thank you very much, and thank you for the invitation. So actually, I will start by one remark, since we just talked about the EU Act. When the EU AI Act was entered into force in Europe, everybody in Europe said, hurrah, we are the first to regulate AI. So I would like to say that this is not the case. China has an extensive array of laws in place covering every aspect of AI. Singapore is very advanced. They already had rules since 2019, and they actually amended their rules based on the case of GPT-2. While us in Europe, we suddenly discovered ChatGPT last year, and we said, woohoo, we're going to adapt our rules. And what we did is that we put into place more lenient rules, because we thought we could build up some European LLMs, large language model, like the equivalent of ChatGPT. So we put lenient rules, more lenient rules in place for ChatGPT and the like, compared to other AI systems. So I'm not sure it's such a great success, but it's a very interesting example. I would like to integrate into what I'm going to say, and this is why I have no slides, remarks with regard to what the other panelists said. So basically, we started with the definition of AI system, what it is, right? And I understand that there are different AI systems, but actually, from this point of view, I would say that for us, I mean, for those who care about protection of fundamental rights, there should be a strong distinction between deterministic system and probabilistic systems. So to make it short, probabilistic systems are ChatGPT. This has large language models, which means that you give it a sentence, you give it 2 sentences, 3 sentences, and it will give you the probability for a word to appear. And if the probability of the word to be there is high, it will give you this word. So this is why what Mr. Ken said before, this is not a knowledge system. It has no clue. It's just based on probability. And deterministic systems, which are not based on probabilities, are safer, because they ensure what we call transparency, meaning that, you can explain how you get to the outcome. And for judges to know how the systems that you used arrived at a certain outcome, I think is the basis of the rule of law and how you take decisions. So this is a key concern. Now you have a distinction between then what is AI systems in the technical sense, and what are AI systems in the legal sense. And here we have a definition which somehow has been accepted in a lot of countries, which is the OECD definition. We find it in the EU AI Act, we find it in the Council of Europe Convention on AI, which has been signed, for example, not only by Council of Europe member states, so almost the entire European continents all can sign, but also, for example, the US signed it very recently on the 5th of September. So this definition is quite the one which has been accepted. And for us, unfortunately, we think that this distinction, it doesn't really make the difference between deterministic systems and probabilistic systems, which is why I say, watch out, this is really something that maybe the people in courts who are in charge of this issue should take into consideration. Moving forward, I would say you also raised the question of why AI is different. Well, my take on that is that it is different because there is a quasi-monopoly as far as development, creation of these systems are concerned. There's just a few big techs. And for example, if I take the European context, we had Aleph Alpha in Germany, but it is disinvesting in AI, and we had Mistral AI in France, and it has been taken over by big techs. And this is why, for example, in Europe, we adopted some rules which are the Digital Market Act and the Federal Trade Commission, for example, in the US, is also looking at issues of competition, because it might not be healthy to have the AI market concentrated in the end of a few big techs, which develops narratives about how AI is great, perhaps without truly looking at the risks of AI. So, and at the governance level, I would say that there are a lot of rules which have been adopted recently because of ChatGPT. Actually, at the international level, everyone woke up and said, whoa, there might be risks. Maybe since AI is deployed all over the world, we should have rules, common rules, to have a sense of what we should do about these systems, both the promises, but also the risks. So we already had the OECD AI principle. We have the UNESCO recommendation on the ethics of AI, which has been adopted by 193 countries, and the US said yes as well about it. We have the G7 Hiroshima principle, the Council of Europe, etc., etc. I wanted to say a word about the Council of Europe, but for the sake of time, I will refrain from it. I think it's an interesting framework. Why? Because first, the Council of Europe Treaty can be signed and ratified. This is the most important part by any country in the world. And it put into place some key principles you should keep into consideration: human dignity and autonomy, transparency and oversight, accountability and responsibility, equality and non-discrimination, privacy and personal data protection, reliability, safe innovation, remedies and procedural safeguards, and of course, assessment and mitigation of risks. And if I mention that, it is because for all these key principles, courts might want to integrate them in their assessment of whether to adopt AI and how and for which use cases. So I think this list for that is very important. But as I said, what we see at the international level with all these rules and even with the EU Act, the key word right now is interoperability. Woohoo! We would have the same rules applied everywhere. But what does interoperability means exactly? It's the lowering down of fundamental rights protection to the lowest common denominator. So this is kind of tricky. For example, when in some international arena, we hear the question, oops, but what is the rule of law? Are you sure? It seems to me that it is a fuzzy concept. I think it is very surprising to hear it, and for judges, it's quite worrying. It is important to look at best practices in the world because there are possibly common issues. It's nice that your international association look at it. It's good if you can compare use case and think in terms of, shall we use them? Shall we use it in that case or no? But what is also important is to think about whether there's the same notion of justice everywhere, since we talk about interoperability. Not sure whether it is the same in democratic and non-democratic regimes, for example. It might be different. And when we hear about two different concepts of governance, like agile governance and regulation or hard law, well, I think we should also put a distinction between agile governance adopted in non-democratic countries, where you should follow the rules, even if it's supposed to be agile, and hard law when it is an agile governance when it is not in a democratic country versus hard law. So I think that here we should be cautious. Frankly enough, if I take the EU Act, what I would say is that we put into place a nice framework, I think, for those who want to have a look, it's in Article 27 of the EU Act, is the Fundamental Rights Impact Assessment. Why do I mention it? Because in it, we ask key questions that someone who wants to adopt AI should ask himself or herself. But since I don't have time anymore, I won't go through it. You can go through it. I also, on my LinkedIn, posted an example of a case by a Dutch judge, and I listed the kind of questions you can ask yourself. But I would say, apart from this and for administration, there is another key point, key examples that could be taken into consideration. It is AI public registries. It has been developed by some cities in Europe mainly, and they ask themselves questions such as, first, shall we adopt AI? Are there alternatives? Because you talk in terms of cost, but maybe we should think in terms of sustainability. ChatGPT cannot be adopted in all courts in the world. This is simply impossible, right? And this AI public registry for administration of justice could be a good example. A last point that I would like to agree with what Mr. Ken said, is that, yes, it is important to think of which red lines you would put into place, for which case you wouldn't use AI. And for the others, each case are not similar. For summarizing a text, it's fine. I saw you talked about translation. Actually, when you translate through the use of ChatGPT, there are issues of accuracy of translation, and it is a problem in the framework of a court, I think. And there are a lot of different issues that I cannot go through, I'm sorry, because I need to be concise. But basically, my key message would be there. Governance is fine, general rules is fine. What matters is how to operationalize them. And for that, in courts, you need people who have both the technical background to do that, the legal background to do that, and very importantly, the common sense, because most of the questions are actually common sense. Thank you very much for the invitation. And if we have time to take a few questions, with pleasure.
Well, thank you so much. But just over and over again, our panelists are packing so much material into short periods of time. Again, it would be nice to have all day, all week, all month, whatever, that we would need to go through this. And yes, even in Singapore, I'm sure you're going to get to the point in the conference saying we need more time. But this is great. Karine, you mentioned some materials and laws and documents or whatever. If you could submit them for us to put that as a list with links on the website for this webinar and or just IACA in general, that would be wonderful, and we can add it to what Kevin had earlier in terms of some other materials. So any of the speakers, if you've got some good materials that we can put a resource list together, that would be really nice to do. I just have one observation about the whole governance thing that stuck in my head recently when I read an article. So often when governance and passing laws and regulations and policies, we say this is what's allowable or what's not allowable. That this is prohibited uses and this is too much of a risk. But we need to also pay attention to, well, what's okay to use it for, and where is it allowable? Because too often with the policies and things, we put fear into the heart of everyone and saying, "Whoa, it's too risky. I'm not going to do it at all," and miss the opportunity. So just thought I'd throw that in there as my own personal observation on that point. We're right up against the hour and a half. There's really not much in the way, unless there's new Q&A, right, that just popped up, which is a thank you. So great. Do any of the panelists have a question for another panelist of each other that you would like to ask each other? I think that would be an interesting thing to see if it prompts any questions or comments.
I would just like to say that I'm thrilled that everyone took the time to join in today. I really appreciate your expertise, and I look at this more as a beginning than an end. I'd like to continue this conversation, and I think if IACA is able to do some more of this in the future, it may be very beneficial to our members.
Righto. And so I'm sure the IACA leadership, of which we've got the president and president-elect right here, and other heavily involved people will see how this webinar went and follow it up post Singapore. We are at the time break here. So again, I think we've covered a lot of material here today. It was very brief in terms of skimming the surface of so many deep topics. I encourage everyone to explore some of the materials and things. Go to the Singapore conference if you can, and attend the sessions, and hopefully do more follow up in the future. I'm sure there'll be more webinars, more articles, and more information, because that's where we are today. And now on the screen is the promo slide for the IACA conference, for those of you that wanted more information about that. And again, thank you for the panelists, and thank you for everyone for registering for it, and enjoy the rest of your day or night, depending upon where you are.
So much.
Thank you all.
Thank you. I hope to see as many of you in Singapore as possible. Thank you.
Thank you.
Forward to seeing you in person there. It's been a real pleasure.